Hey everyone, welcome back to the channel. Zheng Jia was a chartered accountant who had figured out a profitable business model, helping foreigners set up companies in Singapore. He not only incorporated the companies and provided secretarial services, he also acted as the local resident director, a legal requirement for all Singapore incorporated companies without a local director. For a modest annual fee, clients could get a Singapore-registered company complete with a compliant-looking director. Zheng knew exactly what his role entailed under the Companies Act, but instead of fulfilling those duties, he chose to ignore them entirely. His practice grew so rapidly that he couldn't manage it alone, so he hired another man, Beng Hua, to serve as a nominee director for even more companies. At the time unemployed and with no prior experience as a director, was told by Zheng that he didn't need to actually run the company or monitor the accounts. Between them, Zheng and became directors of hundreds of companies. Zheng was named in 384 companies, in 186 companies. Neither of them took the trouble to learn what the companies did, who their clients or the suppliers were, or what business they were actually conducting in Singapore, if any. It was a disaster waiting to happen, and it did. In 2020, a company called Ocean Wave Sheller Private Limited, where Zheng was a director, received over $64,000 US from an American company, Source Substrates LLC, which had been duped in an overseas scam. Within days, the money was transferred to a bank account in China. In another company, Ruiqi Trading Private Limited, where was the nominee director appointed by Zheng, more than USD $2 million and Sing dollars 237,000 flowed through, all proceeds of international fraud. These companies weren't legitimate businesses. They were shells, tools in the hands of criminals. And Zheng, through his deliberate inaction, had helped create and to sustain them. Zheng pleaded guilty to 2 charges. One for failing to exercise reasonable diligence as a director of Ocean Wave, and the second charge for abetting to do the same in Ruiqi. A third similar charge was taken into consideration. At first, the district judge imposed only fines, $3,500 and $5,000 respectively, and disqualified Zheng from acting as a director for 5 years. But the prosecution appealed, arguing that such conduct warranted jail time. The High Court agreed. The Chief Justice of the High Court, Justice Menon, delivering the judgment, made it clear. In Singapore, directors, especially nominee directors, who fail to discharge their statutory duties cannot expect to walk away with just a slap on the wrist. The High Court imposed the sentence of 3 months jail for the first offence and 7 months for the second offence to run consecutively, 10 months in total. This ruling marked a significant shift. The High Court set a new sentencing framework. In cases where a director knowingly fails to supervise a company and thereby facilitates its abuse, such as for scams or illicit activities, a jail sentence is the presumptive starting point. In other words, directors in such cases will likely be jailed unless they can convincingly explain why they shouldn't be jailed. And the reason for this approach is simple. Singapore's reputation as a clean, transparent, and well-regulated business hub is at stake. The High Court recognized that nominee directors who lend their names to companies to act as directors and then look away create a corporate structure that is ripe and ready for abuse by others. In Zheng's case, the court found that he didn't merely overlook his duties. His whole business model was based on deliberately ignoring them. He wasn't just negligent, he was knowingly indifferent. He made money from creating corporate facades for clients he barely knew, turning a blind eye to the risk and reality that these companies would be used for fraud. As the Chief Justice put it, the onus now lies on such directors to justify why they shouldn't go to jail. It is no longer acceptable for someone to say, I was just a name on paper only. If you wear the title of a director, the law expects you to act like one. In the end, Zheng tried to apply for a criminal review of the High Court's decision, arguing that the new sentencing framework shouldn't apply to him. But the court firmly rejected this argument. The judges reminded everyone, the law is not static. When the new framework is needed to address evolving threats like transnational scams abusing Singapore's corporate structures, the courts will not hesitate to act. This case is a powerful lesson for all professionals and entrepreneurs. It's not enough to just fulfill the letter of the law. You must also uphold its spirit. Signing on as a director comes with duties that cannot be subcontracted away or ignored for convenience. Otherwise, the consequences are real and they are serious. Let this case be a reminder not just for nominee directors, but for all those who hold positions of trust. When you hold a title, you bear a responsibility. The moment you forget that, the law will remind you. Thanks for tuning in. Don't forget to like, share, subscribe. I'll see you in the next video.